Hi, good afternoon, everyone. Thank you so much for joining us for today's webinar on global intellectual property rights. My name is Melissa Grosso. I'm the director of the U.S. Commercial Services Office in Middletown, Connecticut. Very pleased to have you all with us. Happy Export Week to everyone. And again, thank you for joining us for today's program. Some really brief housekeeping remarks to start out. We are recording the webinar, so if anyone has any objections, you can disconnect now. As I mentioned, I'm with the U.S. Commercial Service, which is the International Trade Division of the U.S. Department of Commerce. So we help U.S. companies who want to do business internationally. We have offices throughout the United States, as well as at U.S. embassies and consulates in 75 countries. If you'd like to connect with your local U.S. Commercial Service office across the U.S., I've listed a point of contact, a website that has all of our offices across the U.S. listed. And again, as I mentioned, we're in the midst of Export Week. We have a plethora of webinars lined up for you this week, so you can take a look at those at our trade.gov website and sign up for any and all that you are interested in. Again, I'd like to thank our speakers for joining us and taking time out of your schedules. It's a very important topic, so we appreciate you giving us your time. Let me introduce our speakers, and then I'll turn things over to them. With us, we have John Mutchler, who's a partner at Robinson & Cole, and in his current duties, John advises clients on their intellectual property rights. He has specific experience in patent, trademark, copyright prosecution, patent appeals before the USPTO, Patent Trial and Appeal Board, and intellectual property litigation. And John's practice includes patent prosecution and reexamination proceedings, licensing, U.S. government and private company contracting, copyright and trademark consulting and litigation, portfolio management, and IP due diligence in bankruptcy proceedings, asset purchase and sales agreements, business formation, and mergers and acquisitions. We also have with us David Leibovitch, counsel at Robinson & Cole, who focuses his practice on the prosecution of utility and design patent applications, freedom to operate and invalidity opinions, post-grant proceedings at the U.S. Patent and Trademark Office, and district court patent litigation. David assists Fortune 500 companies, medium-sized enterprises, small businesses, and micro-entities with a range of patent matters. He also conducts intellectual property due diligence investigations to assist with mergers and acquisitions. And David is a member of the firm's intellectual property and technology group. So again, two experts with us today, and we very much look forward to your presentation. And I will turn things over to you now. David, you should be able to move. You should be able to move the slides. Thank you so much for joining us.
All right. Well, thank you so much, Melissa, and we're just so grateful to the U.S. Commercial Services for inviting us to do this webinar today. It really means a lot to us to be able to talk about what we have a lot of passion for. So currently, we're both David and I are in the Washington, D.C. office of Robinson & Cole. I'm based in the Hartford, Connecticut office, and David is based out of this office in Washington, D.C. I just want to give you one legal note at the beginning here. You could kind of read it, but the gist of it is we're not providing legal advice here, and we have not established any attorney-client relationship. We're just giving a presentation. So the agenda for today's webinar is I'm going to start off talking about some international U.S. and international trademark protection, turn it over to David on the patent end of things. I'll jump back in and talk about enforcement of intellectual property rights. And Dave will close with really hot topic these days about artificial intelligence and IP challenges. So let me start off by the main question is, what is a trademark? Well, it's not a trade secret. That's something totally different. Trademark is an indicator of the source of the goods or services. So it could be a word, a phrase, a symbol, some type of design, but something that identifies that entity as providing that source, being the source of those goods or services, and distinguishes that entity from others who may be providing similar services or goods. So as I mentioned, it really can be anything. The trademark can be anything that's capable of indicating that unique source indicator of the goods or services. So a couple of ones I'm sure everybody's aware of. The word Nike is clearly a trademark. I'm sure it's registered. It probably has multiple registrations in the US and around the world. The Nike swoosh is an example of purely a logo or design trademark, or it could be both. It could be a combination of a logo or a design with the mark and have color or no color, or no color of just black and white. Another example is just the color all by itself could become a trademark. And the Owen Corning's one was really one of the first entities to get a color, namely the color pink, for trademark registration way back in 1987. And it takes a lot to get that, but it's a lot about advertising and showing how you use that color and how consumers identify pink as Owens Corning being the source of that insulation. So trademarks are all about registration. I think we need to move on to the. Oh, okay. Okay. Yeah. Okay. So the trademarks. How do you get a trademark? Well, you get a trademark, rights in trademark, as soon as you start using the mark in interstate commerce. What do I mean by interstate commerce? That means business between two states in the United States or between a foreign country and any state in the United States. So that action of beginning to use that trademark gives you those rights in the trademark. If you decide that you want to file a registration for an application for registration, that'll give you the ability to use a circle R with it, which I'll talk a little bit about later. And I start off by saying US rights are acquired by use, but the same thing is the same case around the rest of the world. If you get a trademark in the US, well, you only have rights in the US. If you start using the mark in Europe or China or whatever, then it's recommended that you would get an application for registration there because the trademark rights are geographically limited. The other thing I wanted to mention is that the trademark rights are governed by the types of goods or services that you're going to use in selling in your business. So, for example, you could file an application for trademark for goods that's, for example, musical instruments, namely string instruments, or also services. You could file an application for services for repair of musical instruments. So if someone else has a trademark for a similar sounding trademark, let's go back to Nike, for example. This is actually a true story. There's another entity that has a trademark registration for Nike, but it's for hydraulic jacks and pistons. Well, that's fine because that travels in an entirely different channel of trade than does what Nike that we're familiar with for athletic apparel and such. So registration, circle R. You shouldn't use the circle R unless you actually have filed an application and went through the whole process and got approved by the trademark office in whatever country to get it registered. But that doesn't mean you can't start using your trademark. The trademark is all about use, like I said a couple slides back. So as soon as you start using that trademark in interstate commerce, you have what we call common law rights, and you can mark your trademark TM at the end instead of R, circle R. So when you get registration in the US, that covers you in nationwide, every state in the country. And it helps if you ever have to enforce a trademark and give you certain presumptions during trademark litigation infringement actions and the such. So in the US, you file an application, you pick what your trademark is, and you decide what class of goods or services or both that you want to file it for. And then the USPTO, US Patent and Trademark Office, they cover both patents and trademarks, examines the applications according to the federal trademark laws. And the examiners primarily search for conflicting marks that could be confusingly similar to the mark that you're applied for that is in that same group of goods or services. So, all right, so you have your application filed. You're probably going to wait 6 months or more to get an action from the USPTO, some type of office action, as we call it. So the applications could be refused on some type of grounds, such as being confusingly similar with another mark, or else it doesn't conform with other USPTO requirements. For example, you can't get a registration for a trademark that is generic or merely descriptive. So if you wanted to have a trademark for chocolate soda, that is clearly generic. I think the Trademark Trial and Appeal Board found that the trademark footlong was generic for sandwiches. So you have to have something that's preferably a trademark that's arbitrary, completely arbitrary, like a Nike swish, or something that's maybe suggestive. So on that borderline between being suggestive and merely descriptive. The example I like to use is copper tone for suntan lotion. It kind of hints at what's in that container, but it doesn't merely describe what's in there. So after examination, assuming you pass the test of no confusing similar marks and it's not merely descriptive or generic, that's good news. You'll get a notice of publication. So what that means is the trademark office publishes your mark in the Federal Register for a period of opposition. So it gives other entities notice that they're planning on awarding a registration for your mark. And I believe the other entities have 30 to 60 days to oppose a mark if they think they have any grounds for it. The other thing I wanted to mention is when you file an application for trademark, if you're thinking about using it, but you're not using it in interstate commerce, you can file it on what we call an intent to use basis. But before you actually get registration, you'd have to amend to in use and provide evidence, we call it a specimen, showing evidence of use of that mark in interstate commerce. So for goods, that evidence has to be showing the mark on use of the product itself or on the packaging. And for services, it could be like a website, web page or whatever that uses that mark associated with services. Talk a lot about US, but most countries also have similar type of policies and procedures and laws for filing trademarks around the world in whatever country. And there's also an international trademark, which is referred to as the Madrid Protocol, which I think I address on a later slide. And in Europe, you can file for a European community trademark, which gives you protection in multiple countries within the European Union. I mentioned before about the US requirement of proving and providing that specimen or evidence of use in commerce, but most other countries don't have that requirement. But they all do have a process like the opposition process once the mark works its way through the system. I mentioned the other types of international venues for filing trademarks. One is through WIPO. WIPO is the World Intellectual Property Organization, and the Madrid Protocol, which covers multiple countries. And it could, if you're going to file in multiple countries, it could be a cost savings to file through, say, the Madrid Protocol, rather than filing in each country individually. One thing I like about trademarks is that there's really no expiration. You can continue using and have rights in that trademark, but as long as you continue to use it in commerce. Most countries have a requirement of providing some type of payment for a renewal every 10 years. Some countries, like the US, require you to provide that specimen along with that renewal payment when you try to renew in that 10-year period. One thing to mention, I'll probably get into later, is if you're using a mark, you should keep good records of it, of how you're using it, your screenshots, your sales, purchase orders, because trademark registrations can be challenged and invalidated for non-use, because trademark rights are based on use. And if you're not using it, you could lose your rights. So with that, I'm going to turn it over to David to talk about patent protection.
Thank you, John. Thank you, Melissa and Jackie, for putting this together as well. Okay, so let's talk about patents. So first we'll look at some just general considerations for putting together a patent strategy, and then we'll look more at various points of patent law. So as a business, here are some questions that you might ask when you're trying to put together a patent strategy. So one would be, and we'll go into each of them, how you intend to use your IP. The other would be who rather, and where are your customers located and your competitors. And then lastly, what are your innovations, and do you own your innovations? So first question, here's a helpful chart to think about how you might intend to use your IP. And in particular, we're going to be talking about patents here versus essentially trade secrets. So as you see, there are three columns: blocking, running, and teaming up. Those are three kind of general strategies. In practice, you might use a combination of those, maybe depending on your product or your particular sectors. So blocking would consist of using patents, for example, to create barriers to entry to competitors. So you innovated, you obtained a patent in order to prevent your competitors from entering your space. And this is most suitable for technologies with long product development times and long exploitation life cycles. So a prime example of this would be the pharmaceutical industry, where it takes a lot of money, it takes a lot of time to develop new drugs. And so that's where you'd find a long product development and exploitation life cycles. The drug will be sold for a long time. And so this is a perfect use for this type of strategy. So you're relying on public rights, such as patent rights. The next strategy, which we call running here, would be kind of the opposite. So you're not filing patents, you're keeping your innovations secret, trade secrets, and then to stay ahead of the competition, instead of creating barriers to entry, what you're doing is you're constantly innovating. And you're staying ahead of the competition because you're innovating so much. This is most suitable for products with fast product cycle times, maybe certain types of software products, maybe. That has its own challenges. Like it's hard to police this kind of setup, because you have to essentially watch your competitors, see if somebody's leaked a trade secret to one of your competitors. But it is a fully viable strategy. Next one is teaming up. So here it's a little bit different from the first. strategy. So you're still obtaining patents, but with the goal of partnering up with some of your competitors or with third parties, maybe. So for example, you might encourage competitors to, by licensing your patents to them, to enter your space to maybe create market acceptance for your product, or you might piggyback on innovations of others by licensing their patent, obtaining a license to their product, to their patents rather, to gain access to new markets. So 3 general strategies. Next question was, who and where are your customers and competitors? And this is quite pertinent to this presentation today. If you're selling a product or a service across the world, you have to be aware of the way that the various jurisdictions across the world are treating various issues of patent law and IP. So at the bottom here, it says patent rights are determined on a country-specific or regional basis. So if you have a US patent, that's not going to have any value in Europe, for example, or in Asia. And in order to obtain, for example, a software patent, a patent on software technology, well, the US and Europe have very different ways of looking at software inventions and evaluating patentability. So it's important to have an idea of what you're stepping into and of where it's going to be possible to protect your invention across the world. So various jurisdictions are going to have different standards for different types of subject matter. They're going to have different confidentiality and privilege laws, different enforcement means. So, you know, either your US IP attorney is going to have contacts with attorneys in those various jurisdictions, or you're going to have to make sure to consult with the attorneys in each jurisdiction independently. Next is what are your innovations and do you own them? So this gets more into almost employee management or kind of company culture. So you want to make sure you're setting up a culture where you're capturing your innovation. So if you're a startup, for example, there's a lot of turnover typically in startups. So when you're hiring somebody new, they might come in with a knowledge of a trade secret from a competitor. You want to make sure you're guarding against that. And then conversely, as soon as innovations pop up, you want to make sure you're capturing who invented what, and that you're getting disclosures early because of this risk of high turnover, and it becomes more difficult to get patents properly filed if the inventors, for example, are no longer with the company. So that's the second point: who invented what. Keep a good record of innovations. So typically, companies use what's called a invention disclosure form. That's typically, it's a template. It's put together by a patent attorney, and it'll have, you know, a space for the inventor information, bibliographical information, biographical information rather, the subject matter, the date of the invention, the date it may have been disclosed or sold, all those kind of important patent points that you want to make sure that your patent attorney is aware of when putting together the application. Different jurisdictions have different grace periods. So for example, in the US, you essentially have a year to file an application after you've disclosed the invention. That's not true of other jurisdictions. So if you plan to file abroad, you want to really be careful not to disclose your invention before you get something on file. Last point about incentivizing employees to submit invention disclosures. You know, that companies sometimes have a monetary incentive to engineers might get monetary reward for obtaining a patent. So now, more specifically with regard to patent law. So patents in the US must be new, non-obvious, and describe a useful invention. similar requirements exist throughout the world. Another one is that the patent application needs to provide written description for the invention and must enable one of ordinary skill in the art to make and use the invention. The invention, for an invention to be patentable, it has to be more than an idea. There's two parts. There's conception and reduction to practice. Conception is essentially the inventor having a clear idea in their head of what the invention is. And then reduction to practice is actually going beyond this conception and into the practical aspect of the invention. So whether the inventor actually constructed the invention, for example, or the act of filing a patent application is also considered a constructive reduction to practice. As I said earlier, foreign jurisdictions have very similar requirements. In some jurisdictions, you may have a requirement to describe a technical problem that is solved by the invention. As we said, patent rights are territorial. And then also an important point, a patent doesn't give you the right to practice your invention. It only gives you the right to exclude others, to prevent others from practicing your invention. Okay, the US is a first inventor to file jurisdiction. What does that mean? That means if you have two inventors, inventor A and inventor B, and they independently invented the same thing, A invented it first before B, but B files first. B files a patent application before A does. B will be entitled to the patent. They're both inventors, but the one that filed first will be the first inventor to file. And so you need to file early, the earliest possible after you've invented something. I talked about the US grace period of 1 year. The US permits disclosure prior to filing the patent, but as I said earlier, that's not true of other jurisdictions. You want to make sure that you limit those disclosures completely or as much as possible. And whenever you're disclosing your technology prior to filing a patent application, use a non-disclosure agreement, an NDA, to the extent possible. More generally, there's various types of patent applications in the US. So there's utility patents, which are the kinds of patents that you probably have in mind. There's design patents rather, that protect ornamental designs for articles of manufacture, and then plant patents. When you're filing a utility patent application, you have two types of applications. There's the non-provisional, there's the provisional application that never matures into a granted patent, but it gives you a year to prepare your non-provisional application, maybe make a few changes along the way. The filing fees for a provisional application are a lot less than for the non-provisional. So typically companies will file the provisional application first, make sure this is a viable project, and then within a year of that, they'll file the non-provisional application, which will be examined and can mature into a granted patent. And then there's no such thing as an international patent because patent law is jurisdictional. However, there is a PCT application, which is essentially an international patent application. It is also somewhat of a placeholder in the sense that you file your international patent application and then you have a certain amount of time to decide where you're actually going to pursue patent protection, in which country. And then as you enter those different jurisdictions, each will become its own patent application that will be examined by the respective jurisdiction. But if you already know where you want to pursue patent protection, then instead of filing a PCT, you might just directly file patent applications in those countries, in those different jurisdictions. Maybe save some money. As I said earlier, the US has a grace period, not true of other jurisdictions. Some do, some don't. But most countries outside the US are absolute novelty countries. So if there's any public disclosure before you file a patent, you're out of luck. You can't get a patent there. So really make sure, if you're going to potentially obtain patent protection outside the US, make sure you're not disclosing really anything, selling anything, publishing anything before you file a patent application. So that's that. I'll hand it back to John for enforcement.
Thank you, David. All right, let's move on to the next slide there. So let's start off talking a little bit about patent enforcement. David mentioned before about what your rights in a patent are, the right to exclude others from making, using, or selling it. So what that means is that, let me give you an example. So if you have a patent for, say, a door assembly that it comprises a hinge, a handle, and a peephole, you get a patent granted for that. Great. You can exclude others from making, using, or selling that door assembly. But if someone else, a competitor, has a patent for a door assembly comprising a hinge and handle, but no peephole, you can't go ahead and make that more simplified door with the door assembly and the hinge, but the door assembly with the hinge and the handle, but no peephole. So that's the concept. Is you'd have to maybe get a cross license or something. But on the other hand, the entity that has the patent, more simple one for the door assembly with the hinge, couldn't make, use, or sell that door that also has the peephole in it. So that's the concept of the rights, that the right to exclude others. So any violation of those rights would be considered patent infringement. And the whole process of enforcing your patent starts with providing notice to the infringer that you have a patent. You can do that through what we call a cease and desist letter, providing a demand that they stop using your selling whatever it is that your technology. But you should do a reasonable investigation. If you can get a hold of, say, that part that this other entity is trying to sell, have it taken apart to make sure that it has all those components in it. For example, the hinge, the handle, and the peephole. You got to make sure that you really have some good evidence that what you think is infringing really is. And hopefully that other entity will cease and go away and stop using it. But if not, you may have to get into a patent infringement lawsuit. So just like getting a patent, enforcing a patent is very country specific. So if you want to enforce it in the US, then you're going to have to file a patent infringement lawsuit in federal court. Anytime you get into any litigation in federal court, it's a very costly proceeding and a very lengthy proceeding. A lot of entities feel that, well, if I have a patent, I could prevent others from making, using, or selling it, which I just said. But the statutory award for patent infringement is a reasonable royalty. That's money, damages. The injunctive relief, this preventing others from making, using, or selling, is what we refer to in the legal world as an equitable relief. So it's really up to the court to look at the facts in each situation to determine if it's proper to enforce the injunctive relief of not having that other entity sell it. And while I'm thinking of it, there's some other countries have a procedure where Germany, for instance, where if you suspect that a competitor may be infringing, you can request the court for an inspection. So you can show up surprise at their door with your attorney, an expert, and the bailiff, and do an inspection of their facility to see if they actually are infringing, and then decide whether you want to go ahead with the lawsuit. So moving over to trademarks, this is the right side. I just jumped back on patents for a second. So with trademarks, I said, well, to get the trademark, you gotta show that you're using the mark in interstate commerce. So if you're going to enforce it, you've got to do the same thing. So you've got to show that, you know, you've had sales in that country, contracts, whatever type of evidence that shows that you're actually, you know, using that mark in that particular country. Because if you don't, you know, the natural defense is, well, you're not using it, then you can't enforce it. Your trademark's invalid. So in particular, if you're an entity that has distributors in foreign countries, it's very important that you have a very explicit agreement that indicates who owns the trademark that you're allowing them to use, because it's been known that certain distributors decide to claim ownership of your trademark and then lock you out of your own business in those countries. It's happened to some of my clients in China. It took years to fight to turn that around. So enforcement of trademarks is pretty much procedurally the same. It starts off with a demand letter, a cease and desist, as we call it in that legal world. And if they stop using it, then great. If not, then you're back into federal court. Trademark infringement is a federal court proceeding, very expensive, very costly, lengthy proceeding. All right, so in addition to the infringement proceedings, a specific, so if you get sued for patent infringement, the first thing the infringer is going to come back and say is say, well, in defense, your patent's not valid. It shouldn't have been granted in the first place for whatever reasons. And there's various ways of trying to prove that. I'll start with the cheapest one is the reexamination procedure, and that's done before the U.S. Patent and Trademark Office. And it's what we call an ex parte procedure. So once that defendant, the infringer, files a reexamination proceeding, he's got no further say, he or she has no further say, and it's up to the patent holder to defend why his or her patent is valid. Another but more costly proceeding, and this is an inter partes proceeding, can proceed, and a post-grant review is very similar to the inter partes procedure, but it is only available within 9 months of when the patent is granted. All that said and done, if you really want to crank things up, you can just file a declaration of invalidity in federal court to try to have the court rule that the patent is invalid. On the trademark side, again, got the cease and desist letter. Be careful to try to keep records of when you first started using that trademark in interstate commerce, because if you're trying to sue a potential trademark infringer and all of a sudden they can produce evidence that they were actually using the mark before you started using the mark, then that could be problematic and you'd have a hard time stopping them. The other thing is, I mentioned during the application process, when the trademark office decides to publish your application for opposition, anyone could file an opposition proceeding and opposing the mark and try to get it canceled before it actually gets registered. On the flip side is, if you find out about a mark that actually registered already, you're not, if you're seeing that someone's potentially infringing your mark, you're not out of luck. You can file a cancellation proceeding and try to cancel that mark either for non-use or some other grounds that are available for that. Of course, there's always the federal court, and you can go there and seek invalidity or nullity proceeding before the federal courts to have the trademark canceled. With that, I'll turn it back over to David on the latest on artificial intelligence.
Thank you, John. Okay, so AI has kind of rocked the world recently in every sector, and IP, intellectual property, is one of them. So we'll talk about some potential challenges in patent law, trademarks, and copyrights even. So the first question is whether AI can be a patent inventor. And as part of what was referred to as the Artificial Inventor Project, a group of people filed patent applications on AI-generated inventions that were produced by a neural network system. And they filed those applications kind of throughout the world. And so far, the outcome has been, with the exception of South Africa, all of the US, Europe, European Patent Office, United Kingdom, and Australia have all found that AI cannot be an inventor. So in the US, for example, the courts have said a patent inventor has to be human. So what does that mean? That means if you're using AI to generate an invention, essentially you can't file that invention as a patent application in the US. So that's significant, something to be aware of. The balance will be, whether, of course, AI was an inventor or you're just using AI as a tool, to generate the invention. But it's a very significant challenge. Other challenges in patent law relating to AI are subject matter eligibility, which really pertains to any computer invention. Another one is written description and enablement, this requirement that we talked about earlier, that the application has to describe how to make and use the invention. That's a problem with AI. It's a challenge with some AI inventions where you have, let's say, a neural network system and you've trained it, you know how you trained it, but now that it's trained, you don't really, it's somewhat of a black box at that point. You can't really describe how it works. You have a network architecture maybe, and it's working because you've trained it to work a certain way, but you wouldn't be able to really describe with any significant, any meaningful description of how it really works. There's a series of coefficients that are calculated internally, but it's somewhat of a black box, hard to describe. So that's a problem on, what are the requirements for written description and enablement in the US for AI inventions? Still in the works. Another one would be if you've used generative AI like ChatGPT, for example. You can now ask ChatGPT to generate code. So you can say, ChatGPT, write me a Tetris game, or some other program, and it'll give you the code. And it's been trained using available technology, available codes. And the question becomes, what if the AI generates a code that infringes on a patent, so without really controlling how this thing is generated? You wouldn't really necessarily know that it used proprietary, maybe protected technology. So that's one challenge. Similar challenge in trademarks. You can imagine that generative AI is being trained using, again, publicly available data. So if you're asking ChatGPT to come up with your next company logo, it might borrow from a known logo and give you something that potentially infringes on somebody else's trademark. So another potential risk there as well. Same with copyright. The content generated by AI might be infringing copyrighted material because it was trained using copyrighted material, perhaps. So you wouldn't necessarily know on the receiving end. Another challenge in copyright is whether, if you used AI to generate content, whether that is copyrightable. you can get a copyright on that. And so right now it's again still in the works, but in the US, the Copyright Office asks applicants to identify if any portion of the copyrighted content was generated by AI and to identify what was generated by the human and by AI. And you're really entitled to protection for the human generated portion. And then the question of who owns the copyright, that's a very important one because that really depends. If you're using, again, ChatGPT versus some other system, read the terms of service because they'll tell you, by using our system, you own all the rights or we own all the rights to whatever the system produces. So that's another big red flag to be aware of in the context of copyrights. And that concludes our presentation. We'll take any questions. I see there might be some in the chat, or maybe Melissa can chime in. Thank you for your attention.
Thank you so much, David. Thank you, John. Great, interesting presentation. John and I have done a number of these over the years. Never thought we would be talking about AI in terms of IP. So it's an interesting nuance for sure. So I do see we had a question come in. Just a reminder for folks, on the bottom right corner of your screen, there's a Q&A box. So if you could enter your questions there. First question is, in advertising copy, can our competitors reference products for which we have a registered trademark? If so, do they need to note that the product name is a registered trademark of our company, or do they simply need to include the circle R with the product name?
Yeah, I could answer that, and it really depends on exactly what the use is. If it's just someone's just using the trademark and provides acknowledgement that they're using that someone else, that they don't have it, that they don't own that trademark, then that use could be considered acceptable. But in general, I take kind of a harder line on that. Anytime that potential competitor is using your trademark with or without a circle R next to it, I would recommend having them, asking them or demanding that they take it down.
Thank you, John. Appreciate the comments on that. While we wait for other questions to come in, I have a couple quick questions of my own, if possible. In a general sense, if someone knows that their patent or trademark has been infringed internationally, what are the first couple steps that you would recommend they take? I know we talked from a broad brush perspective, some things that they can do, but sort of steps 1, 2, 3, what would you recommend?
Take down our patents.
Yeah, I didn't catch the beginning. Sorry, could you repeat?
Sure. If a company is aware that their patent or trademark has been infringed on the international stage,
Yeah.
as you will, what would the first couple steps be that you recommend that they take?
Well, first step is to contact an attorney in that jurisdiction. In that, if the market is in, say, Germany, then you need to contact a German IP attorney. If you have a US attorney, the easiest way to do that would be to go through that US attorney, because they can guide you in the process on how to even interact with foreign counsel, and then just follow their guidance. It's going to be a different approach in each country. John, do you have any other suggestions?
Yeah, that's exactly how I would answer it. Is most U.S. law firms have clients that they file trademarks all around the world, and because of that, the U.S. attorneys have long held established relationships with law firms around the world that they trust and know do good work. The other thing is that certain countries in Europe, Sweden, Germany, they have two different types of patent attorneys. One is a patent attorney that does the prosecution side, and then there's patent litigators. They're actually lawyers. So it's a combination of getting a firm that has both the litigators as well as the prosecutors, because it usually takes the team of the prosecution attorney, patent prosecution attorney, and the litigation attorney, the lawyer, as they so refer to address the patent infringement in whatever foreign country.
Great, thank you. I see we had another question come in. Excuse me, is there a timeline when we may file international patent application on US issued non-provisional patents? Is there an economical way to file for Asia?
Yeah, if the patent was issued in the US, that's now public. It's a public, when the patent issues, it's a public document. It's my sense is that would be too late to file an international patent application. As far as the economical way to file for Asia, I mean, in my experience, I've advised clients to just file a PCT application, and then after the 30 months or 31 months, figure out exactly which countries in Asia they want to pursue I'm not aware of somewhat of an economical way to file in Asia.
Yeah, I would certainly agree with that. I mean, it's crystal clear that once you have a granted U.S. issued U.S. patent, then that if you try to file another patent, say in Asia or wherever around the world, that your own patent is going to be used against you as prior art, and prior art being, well, someone else has already invented it, even though it was you, it was public information. You're barred from being able to get a patent, and it would be a waste of money to try to do so.
Yeah, you may want to kind of piggyback on that invention, and if you can further innovate, come up with a further improvement or element that's patentably, distinguishable, then you can certainly have that improved, technology filed as a new patent application, for example, as an international patent application. But on the same subject matter that's disclosed, it's got to have something beyond, something meaningful beyond what's described in this US issued patent, would be my understanding. Thank you for the question.
Thanks for the great answers. One of the questions coming in, the company's asking, so as soon as we apply for a patent in the United States, we need to have also applied for the same patent in every country around the world?
As soon as we apply for a patent in the United States, we need to also apply the same patent in every country around the world. No, so one approach is to file just a provisional application in the US. So the filing fees are very minimal, and that gives you a year to file either a US non-provisional application or a PCT application, an international patent application,
or even a direct foreign application.
Right. That would claim priority to that provisional. So that this provisional application is a very valuable tool because, again, it's cheap. Well, it's cheap on the filing fee side. It shouldn't be drafted cheaply. It should be really drafted in a way that it looks essentially like a non-provisional application. You don't want to be adding so much new stuff when you convert that to a non-provisional application, or else you might not really benefit from priority. So you want to make sure everything's in that provisional application, but the filing fees are cheap and you just file one, and that gives you a year to figure out the market. And then after that, you can decide either to file, as John said, individually in different countries, and that would claim priority each to this provisional, or you file a PCT, which gives you another 2.5 years.
Yeah, and just to add to that, you don't have to file a provisional. That's totally optional. You could say, I'm just going to start by filing a non-provisional day one, and you still have that 1 year time frame to preserve your priority to that non-provisional, same as if you would have filed a non-provisional. So the short answer to your question is no. You don't have to file them all at the same time. You've got 1 year to do that.
Great. Thank you, John. Thank you, David. And I think that answered the next question that came in, which is along a similar vein. A question on the artificial intelligence side of things. Since this seems to be a very nuanced part of intellectual property, where can companies find updates on any IP laws that are changing, and again, in relation to artificial intelligence?
That's great. Great point. So the Patent Office has the U.S. Patent Office, uspto.gov, has a page dedicated to artificial intelligence. It might even be like uspto.gov/artificial intelligence, something like that. You can just Google it, and they have really good information. They have some also global kind of IP information, and then WIPO, the World Intellectual Property Organization, so WIPO.org, also has, so that's the organization that handles those PCT applications, right? And so they have also a page, I think, dedicated to AI, and they put out reports every year. And that would be one source. Otherwise, your IP attorney is probably the best source, because they'll keep up with this kind of stuff, and they'll know where to get the information.
And I see another question has come in. I know
coming up here again, and it's
are the rules the same? Well, actually, wasn't there another question that was a little bit
it's
different,
related
right?
to it, yeah, I think. The rules are not the same for patents and trademarks.
Actually,
So the question was, do you have to file a trademark or copyright application in the US and internationally at the same time? The answer is the same, no, but the time period is different. For example, if you file a US trademark application, you've got 6 months, not a year, to be able to claim priority back to that US application. And all is not lost if you don't file within that 6 months. It just gives you some additional insurance that someone else maybe didn't file that same trademark in between that 6 months or after that 6 months period that you'd lose it. And copyrights, there's really no reason to have to file copyright applications in the US and internationally at the same time. If you came across having to enforce US copyrights around the world somewhere, you can go ahead and file in whatever country you want to. You could even try to enforce it through what we call the Berne Convention, which countries who've signed on to it have respected other countries' rights in copyright applications in foreign countries.
Thanks, John. I appreciate the clarification on that. That's helpful. Looks like we are at the top of the hour, so let me just ask David, John, any final thoughts for the audience?
Well, I think that the one thing I would say is on the trademark side, I've too often seen companies spending money, starting up a website, filing trademark applications on their own, and finding out that their trademark they picked is merely descriptive of their services, or it falls right on top of someone else's trademark, and you waste all that money. Same thing on the patent side. If you've got this great invention and you want to go file a patent application for it, I would recommend having a search done first to try to knock out either on the trademark side, knock out other trademarks, or on the patent side, knock out and find and try to design around any other patents that may have been out there before.
David?
Final thoughts from me. No, I think that was great. Maybe don't trust AI.
And as my own final thought, other than thank you both for sharing your expertise this afternoon, we will share the recording with folks on the call. I'll also mention just on the international side, just keep in mind the U.S. Department of Commerce does have a great informational resource. We do not provide legal advice, but if you go to stopfakes.gov, we have different country toolkits that give you a broad brush overview of what their intellectual property situation looks like and things to be mindful of. So just keep that in mind. Again, we cannot provide legal advice, but it is a helpful starting point in addition to working with a patent and trademark attorney. So John, David, again, thank you so much for your time this afternoon, and
My
have a great
pleasure.
rest of your
Thank
day.
you.
All right.
Thank you.
Take care.
Bye-bye.